Hi guys, I am Tanvi Ma'am. I am a criminal lawyer and I am the legal faculty for the legal section in this particular class. Today we will be covering basics of criminal law. So, what exactly comes under criminal law? The first thing that comes under criminal law is your first information report. So, first information report is something that not many law students will learn about in their law school, but it is very important because it falls under the Code of Criminal Procedure, which is a very important law for every law student. So something that sets the criminal law into motion is your first information report. What is the purpose of the first information report? Is that to give some sort of information to the investigating authorities, which is the police officer, to start their investigation into any crime or any offense which has been committed. So what are the contents of a first information report? A first information report consists of all the information of that particular incident which has occurred. For example, the name of the people who have committed the crime, the date and place at which such incident has occurred, and any other related information which the informant thinks is necessary for the investigating authorities to conduct a fair investigation. Now, why I am continuously talking about the first information report is that because under criminal law, there are two kinds of offences. First is a cognizable offence and second is a non-cognizable offence. A cognizable offence is an offence which the police officers, an investigating authority, has the power to investigate. That is, all your serious and grave offences such as your murder, your theft, your criminal conspiracy, etc. falls under a cognizable offence, which are serious in nature, which means that a police officer can immediately start investigation without having to take a warrant from the court. What is a warrant? It is a piece of document that gives permission to a police officer to arrest a person. Okay, what is a non-cognizable offence? A non-cognizable offence is any offence which a police officer does not have the power to investigate upon unless he has an order from the court. So now we have understood the difference between cognizable offence and non-cognizable offence, which are the kinds of offences that fall under criminal law. First information report is a piece of document which falls under cognizable offence cases, right? So whenever you see any cognizable offence such as a murder or a theft or a cheating occurring, you will go to the police station and inform to the police that so and so has occurred, and it is the duty of the police officer to immediately start that investigation. So this is your first information report from the perspective of your investigating authorities and the informant, which is a person who complains about a particular offense. Being a criminal lawyer, I study vastly into the rights of an accused person. Now, there may be occurrences with you or people that you know that you get falsely accused of committing some crime. So, when that happens, even for example, a mere thing such as getting caught for violating a traffic rule, right? Even then, even if you haven't done something, what are your rights in that case? You are still an accused in that case. So what would be your rights? Your first right would be that whatever information the police officer records against you, he has to give that copy of information to you free of cost. And he has to give it to you in a language that you अंडरस्टैंड फॉर एग्जाम्पल अगर आप नॉर्थ इंडिया से हो या फिर अगर आपको मराठी नहीं आता एंड यूजुअली ऑल द कोर्ट डॉक्यूमेंट्स आर रिटन इन मराठी तो अगर आपको मराठी नहीं आता तो फिर इट इज़ द ड्यूटी ऑफ द पुलिस ऑफिसर टू राइट सच एन इंफॉर्मेशन एंड मेक यू अंडरस्टैंड इट इन द लैंग्वेज दैट यू नो. So this is your first and primary right as a person against whom some particular investigation or any other law is being taken into force. Okay, what would be your second right? Your second right, which is also a fundamental right given under the Constitution of India, is your right against self-incrimination. Okay, तो for example, अगर आपको police officer ने arrest किया based on some robbery or theft, तो वो आपको पुलिस स्टेशन लेके जाएंगे और वो आपको बोलेंगे कि आप कन्फेस कर दो, ठीक है। अगर उन्होंने आपको कन्फेस कर दिया, अगर आपने उनको कन्फेस कर दिया, तो फिर वो जो पर्टिकुलर कन्फेशन है उसके बेसिस पे आपको पनिशमेंट नहीं मिलेगा, बिकॉज द लॉ सेज दैट यू हैव अ राइट अगेंस्ट सेल्फ sorry,
take the last part again. Take the perspective.
yeah, what happened?
He's like for videos.
I thought I went wrong.
No.
You will bilingual. Very important. Hindi and English.
Be bilingual, right?
Be bilingual.
अच्छा लगा ना?
बढ़िया लग रहा है क्योंकि सुनने में बढ़िया लग रहा है. It will not be monotonous. It will be impactful
ठीक है.
for both kind of.
You'll cut this part out, right?
Obviously. How can we put this?
Okay. So where was I? I forgot.
You were at no.
If you
If you
write
got
against self-incrimination.
Self-incrimination, Article 20.
20, yeah. Okay. So your second right as an accused is your right against self-incrimination. तो अगर आपको पुलिस ऑफिसर ने अरेस्ट किया बेस्ड ऑन सम रॉबरी और थेफ्ट एंड दे टेक यू टू द पुलिस स्टेशन और आपसे ये कन्फेशन निकाला कि आप फोर्सफुली ये एडमिट कर दो कि आपने ही चोरी की है, ये जो कन्फेशन है इसके बेसिस पे आपको पनिशमेंट नहीं होगा, आपको जेल जाना नहीं पड़ेगा, बिकॉज व्हाट द लॉ सेज इज दैट देयर इज अ राइट अगेंस्ट सेल्फ इंक्रिमिनेशन। माने कि आप जो खुद बोल रहे हैं उसके इंफॉर्मेशन के बेसिस पे आपके अगेंस्ट कोई इन्वेस्टिगेशन, कोई पनिशमेंट नहीं लिया जा सकता। So for example, there are many other judgments and other authorities on this particular aspect which talk about a signature or a document or any other information that is retrieved from a person by a police officer and not in front of the court, by a police officer. Such evidence would not be accepted in court. Okay, so that is your second right against self-incrimination. That is, you cannot be imprisoned upon information that you yourself give to the police in any offense. Okay, तो even suppose अगर हम ट्रैफिक वायलेशन का एग्जाम्पल लिया और अगर आपने एक लाइसेंस दे दिया पुलिस ऑफिसर को जो वो हमेशा मांगते हैं और वो लाइसेंस सपोज एक्सपायर हुआ है या फिर आप खुद बोलते हो कि हाँ मैंने फ़ाइन भरा ही नहीं है, ये जो आप बोल रहे हो ये वो कोर्ट में जाके इसके बेसिस पे आपको इम्प्रिजन नहीं कर सकते। पुलिस ऑफिसर का यही काम है कि वो खुद इन्वेस्टिगेट करके खुद एविडेंस आपके अगेंस्ट निकाल के आपको पनिशमेंट दिलवाए कोर्ट के सामने। तो आई होप आपको ये समझ आया। तीसरी बात जो है वो है कि एज अ अक्यूज पर्सन एंड वेन एवर यू गेट अरेस्टेड by a police officer and any individual that gets arrested by a police officer in relation to a cognizable offence has to be produced before the court within 24 hours. तो ये कॉन्सेप्ट आपने बहुत मूवीज़ में, वीडियोज़ में, सीरीज़ में देखा होगा कि 24 आवर्स के अंदर आपको प्रोड्यूस करना पड़ता है। क्यों करना पड़ता है? बिकॉज एवरीबॉडी नोज दैट custodial interrogation is something that can sometimes lead into violence, can lead into forced confessions. So to protect your right as an accused, as an individual, the law says कि 24 hours के अंदर पुलिस को ये whatever case है वो figure out करके कोर्ट के सामने accused को पेश करना ही पड़ेगा. So one important rule that you must know in relation to all these three rights that I have told you is that a person is always innocent until proven guilty, right? An individual is always innocent until proven guilty. That is the cardinal rule of criminal law. So I hope you enjoyed this lecture, guys. That was it for basics of criminal law.